Good afternoon. I'm Risa Goluboff, and I am the Dean of the Law School here at the University of Virginia. And I first want to say thank you to the School of Data Science and to Danielle D'Andrea for organizing Datapalooza 2019, and to Phil Bourne, my Dean colleague. It's a pleasure to say the School of Data Science and not have it be qualified in any way. So thank you also for inviting the law school to participate and to talk about the relationship between law and data. And thank you to Mike Livermore for putting together this panel. So I talk a lot at the law school about how important lawyers are in creating a more just, equal, and fair society. And they are, I think most people, including a lot of lawyers, think the courts are the key actors, but the courts don't act unless lawyers bring them cases. And so being in the business of training lawyers, I think, is really being in the business of training change makers of all kinds and innovators and people who are out there creating the legal questions that the courts will answer. This is a really exciting time for lawyers and for legal scholars in thinking about data science and how data science is transforming the law, among so many other things, and the possibilities for information technology to transform our legal system. Data can help us in so many ways in thinking about the law, how we understand the impact of current laws. It changes how we think about advising and representing our clients. It helps us improve the delivery of legal services to underserved communities, and it helps us write smarter, more effective laws to govern our society. So we have two scholars here today from the law school faculty who will help us think more deeply and more broadly about the relationship between law and data. Michael Livermore, to my right, is the Edward F. Howry Professor of Law at the law school. His scholarship focuses on environmental law, regulatory law, and the computational analysis of law. In 2019, Mike won the university's Carl McFarland Prize, which honors outstanding research by a junior faculty member at the law school. Prior to joining our faculty in 2013, Mike was the founding executive director of the Institute for Policy Integrity at New York University School of Law, which is a think tank dedicated to improving the quality of government decision-making. You can see the interactions there with data. He holds a BA from the University of Albany, a JD magna cum laude from New York University, where he was a Furman Scholar, graduated Order of the Coif, and was a managing editor of the Law Review. After law school, Mike spent a year as a fellow at NYU's Center on Environmental and Land Use Law, and then clerked for Judge Harry Edwards on the U.S. Court of Appeals for the D.C. Circuit. He recently co-edited the volume Law as Data, Computation, Text, and the Future of Legal Analysis. Law as Data explores this new field of computational legal analysis, which is the study of the law that uses legal text as data. And I wish he had a copy of the book with him, because it's the coolest book cover I've ever seen in a law school. Kevin Cope is to his right, and I have a couple myself, but his is cooler. Kevin Cope is to his right, and Kevin is Associate Professor of Law at the Law School, as well as Associate Professor of Law and Public Policy at the Batten School of Leadership and Public Policy, and affiliated faculty in the Department of Politics. Kevin's research focuses on the measurement of legal and political phenomena. He is most interested in the law and politics of international institutions, migration, and relationships between domestic institutional structure and international behavior. And among the courses he's teaching this year is computational text analysis for legal practice. Kevin received his BA from Ohio State University, his JD from Northwestern University School of Law, where he was a member of the Law Review, an LLM in international law from Georgetown University Law Center, and he is finishing his PhD in political science from the University of Michigan. After law school, Kevin clerked for judges on the U.S. Court of Appeals for the Ninth Circuit, the Northern District of Ohio, and the Court of Federal Claims, and he also practiced in Washington, D.C. in government enforcement litigation at the firm of Skadden Arps. So they're both going to speak about their work, Mike first and then Kevin, and then when they're done, we'll open it up for a Q&A. So Mike, take it away.
Great. Thanks very much, Risa. And it is a real pleasure to be here and an enormously kind of exciting time to be at the intersection of law and data, I think, especially at the University of Virginia. So I thought I would kind of start with a very general bit of background about kind of the relationship of of data analysis and law and legal scholarship, and then talk about what I think of are the really interesting kind of moment that we're in right now, and then forward-looking opportunities for the next handful of years. So if you think about kind of in the broad scope of time, civilization, law has been around for a long time. And the study of law has also been around for an awfully long time. I mean, the legal profession is, it depends on when you want to date this, but the legal profession you can extend back to like the Roman times. And for almost all of that period, law has been largely a qualitative discipline. Law scholarship, folks that think about and try to understand the law broadly, has been a qualitative discipline. And it has intersected with other qualitative disciplines like history, like philosophy. And what legal scholarship has really involved is the close reading of legal texts, statutes or judicial decisions. We can kind of think of some other types of legal texts, but those are the core of what we're talking about. And scholarship involved, again, the close reading of these, and then working to try to understand, synthesize what was happening in the law, think about how the law interacted with other social, political institutions. And that, until fairly recently, was how folks engaged in both legal practice and legal scholarship. But that has changed in the past several decades. So what we can kind of think of as the precursors of the current movement started 20, 30 years ago in what is kind of currently referred to as the empirical legal studies movement. So the idea there is that scholars who had been trained in quantitative disciplines like economics and some related fields, political science, started to think about how quantitative techniques could be used to think about the law and legal institutions. And the data that was used in those in this time frame, and this is still used in this type of data is still frequently used, is not data that's necessarily about the law directly, although that's also possible, but also law that is about kind of society, right? So we can think of a question, for example, classic question in empirical legal studies is, when states adopt or get rid of the death penalty, does that have any effect on crime rates? Or if, again, just to look at states, if a state were to change the rules governing medical malpractice, does that affect insurance rates or the kind of jobs that physicians take, or so on and so forth? And so this type of analysis, one way to think about this is looking at the consequences of different legal regimes. And at the same time, scholars in this domain were interested in the causes of legal change as well. And so kind of canonically or classically, one of the ways that scholars have done this is to think about, for example, the ideology of judges' political views. How does that affect the decisions that they make, both at the Supreme Court, but then also more broadly in the appellate courts? And so there, what the laws actually is encoded, typically in a very kind of what we would think of as a pretty old-fashioned way. So scholars and then really their research assistants would go through and kind of hand code information that was contained in judicial opinions, and then run some essentially pretty straightforward statistical analysis to see, for example, if Republican judges decide cases differently than Democratic judges. And so that kind of takes us up to maybe 10 years ago, and there has been a flourishing of this style of work, and there's many of our colleagues at the University of Virginia do important work in this area. But what's happened in the past several years is the growth of what I like to think of as law as data, right? So here, if you think of kind of Law as Data 1.0 is the hand coding of these judicial opinions. And what we have now, though, is much more sophisticated tools in computational text analysis, natural language processing, network analysis, and kind of related fields that allow us to take these, what are actually very complex, high-dimensional objects, a statute or a judicial opinion, and then render those into a format that we can apply statistical methods, and we can apply data and analytic methods to then learn something about what is going on with the law. And we often will take, so then now we have this new way of thinking about law as data, and we can do the kind of standard empirical legal studies thing, which is to think about the causes and consequences of law, through, careful causal identification, borrowing from social science methods. But also, I think what's kind of very important in this area is the law as data transformation also opens up new vistas for folks who have a more qualitative orientation, or folks drawing from qualitative disciplines. And this is thinking of kind of law as data intersecting with digital humanities and law, basically, right? So historians have started to use these types of techniques, and more broadly within history, but also within legal history. Legal historians are now using these law as data techniques to, for example, identify trends in how courts talk about, race and habeas corpus, for example, is a paper that came out a few years ago. And what the translation to data allows is for scholars, even in a qualitative vein, to extract patterns and trends that would be impossible for a person to see, especially over a very large number of documents. So I have work that analyzes every Supreme Court opinion that's ever been written, and that's actually physically possible in a person's lifetime to read every one of those, but it would take 8 hours a day for the rest of your life, and it would be a good punishment for someone who's done something really terribly wrong. So in any case, it allows, sometimes this is referred to as distance reading, which is a kind of an ability to take a broader look at the landscape of a set of documents, far more than would be possible. I mean, you can look at millions of documents this way, which no human being could ever do. So in this book that Risa mentioned, I'll just talk a little bit about what our goal is there. So this was based on a workshop that was at the Santa Fe Institute a few years ago. And the idea was to kind of pull together a group of scholars that were using these law as data techniques from different disciplines, so political science, economics, computer science, people with machine learning backgrounds, and so on. And what brought us all together was this object of study. We were all studying the law using these techniques, and we were using the same kind of data. And so I'll just give and what we do in the book is the goal was to kind of provide little snapshots of some of this cutting edge research, really to just give a taste of what's going on in the field and to get people excited about the possibilities of this new type of scholarship. So I'll just mention quickly 3 of the projects that we discuss in the book. So just to give you a flavor for what we can learn from this work. So one chapter is examines parole hearings in the state of California. So for a long time, parole hearings didn't mean anything in the state of California because the answer was always no, you didn't get parole. But it turns out that within the last several years and under Governor Brown, there's been a change, and parole grant rates have gone up. So one question we might ask is, what are the factors that determine or influence or are correlated with, at least, or are predictive of a parole rate grant? And so what the researchers for this project did was pull the transcripts from several years worth of parole hearings in California, run them through the text analysis techniques to extract the relevant information, and then start to analyze this data and look for correlations, and also to do some causal identification as well. And they look at factors like the identity of the psychologist that does risk assessment evaluations, and also what is talked about during the hearing, what kinds of themes come up during the parole hearing. And they find both factors like the identity of the psychologist, but also what is discussed in the parole hearing. It's things that we might intuitively think, but they actually identify a qualitative metric or a measure for this stuff. So whether a potential parolee discusses remorse or talks about efforts to overcome a substance abuse problem, those are associated with higher grant rates. So that's an interesting project, and obviously has a real world implications, especially in a time of severe mass incarceration. And so if we're kind of thinking about what are the factors that might help alleviate some pressure on the system, that provides some insights there. Another chapter kind of switches veins and is more predictive in nature. And in that paper, researchers actually with a private company in Washington, D.C. called Fiscal Note, who I've done some work with as well, what they do is they analyze state legislative processes across the country for all 50 states, and they develop predictive models to determine the likelihood that any given bill is going to pass in any given legislative session. And they actually have incredibly good predictive models that are over kind of 90% predictive accuracy based on features of the bill, like who's the co-sponsor, but also on textual features of the bill as well. And so that, again, has quite practical significance where, for example, if you're interested in what's happening with anti-tobacco legislation around the country, these kinds of predictive models can help you forecast what's going on in the future. Final set of projects that I'll just mention briefly. Some of my own work looks at the Supreme Court. And the question is kind of what can we learn through these quantitative techniques about trends in the Supreme Court? So in one paper, co-authors and I look at ways in which the court's writing style has changed over time. One of the things we do a sentiment analysis, which is fairly straightforward, which a lot of people here are probably familiar with, and we find the court has gotten substantially grumpier over the last couple hundred years. So that was interesting. But also we look at, for example, the effect of judicial clerks. So actually all the Supreme Court justices these days hire recent law graduates, and the law graduates help them do research and even help draft the opinions. And so the question was, has that practice actually changed what Supreme Court opinions look like? And we also look at the topics that are discussed in Supreme Court opinions, basically the substance of the Supreme Court opinions, and we ask whether the substance of the Supreme Court is starting to diverge from the types of substance that is discussed in the appellate courts, in the general federal appellate courts. And what we find is over the last 50 years, the court actually has become substantially more distinct in the types of topics that it discusses in its cases compared to the appellate courts. It's much more easy to identify a Supreme Court decision these days than it would have been 50 years ago, just based on the text alone. So all of that I think of as fairly interesting work, but it really just, the way I think of this is this intersection of law and data science generally really opens up this huge landscape of potential questions, new approaches to old questions, and new questions that we never thought to ask before. And we've taken just preliminary steps into this landscape. It's a wonderful landscape there. We found that there's lots of really interesting stuff, and I, for one, certainly am looking forward to continuing to see what's there.
Thank you. Kevin?
Thanks, Risa. Thanks, Mike. So I'm just going to pick up where Mike left off and talk about three sort of somewhat different types of projects that I'm currently working on. Even though they all involved text as data in some way, they use very different approaches, and I think they illustrate the wide variety of methods and possibilities for these techniques. So I'm just going to give you what we call the elevator pitch for each piece, and then I'm happy to elaborate and consider how they connect with the themes that Risa and Mike talked about during the Q&A. So the first piece a co-author and I started working on a few months ago involves scraping and analyzing the press releases of 13 years of ICE, Immigration Customs Enforcement press releases. So there's been a great deal of studies of the causes and effects of different immigration phenomena, how many people are removed, how many people enter the country unlawfully, what leads people to stay or leave, and so forth, how they're treated and the conditions people, non-residents, face while they're here. But there's been almost no analysis or consideration of the language that governments use to communicate these enforcement strategies to the public. So co-author and I, he's the web scraping guru, and he was able to, I won't call it hack into the ICE website because it's technically freely available, but it turns out they really don't like it when you do this. So he went on a supercomputer at the University of Michigan and began scraping the data. It takes a while. And eventually they would recognize the server and kick him off, and then you have to move to a different one anyway. But now we have downloaded onto the cloud 10,000 press releases covering the entire span of the Department of Homeland Security from 2003 until the present. And we're beginning to analyze those. So what types of questions can we answer this? So one theory is that different administrations with different enforcement priorities and different ways of thinking about immigration would communicate their actions differently. We know what the actions are. We know about who is targeted, whether it's employers or employees, people with criminal records, people without, at the border or the interior. But it's interesting to see how do governments communicate this. And so we do an analysis of the entire corpus of 10,000 or so documents. That's a few per day. And we're beginning to get some results. It's still very much in the works. But we're seeing that there is a discontinuity between administrations, which lags a few months after the administration takes over, in the priorities that the administration talks about. So our results thus far, which are very preliminary, aren't that surprising. We see, for example, between Obama and Trump, we see a lot more talk about removal and enforcement and less talk about, say, financial crimes. Starting with Obama, we saw less talk about removals and actually more talk about criminal records. And that jives with the reality that the Obama administration prioritized the removal of people with criminal records and deprioritized other folks. So that's very early works, and we hope that we'll discover a few more interesting phenomena about how the government communicates these things. And we hope that it may generalize to other sorts of enforcement phenomena, such as the FBI and so forth. The second project is also about the statements of the government, but using very different method. So I was interested in how governments negotiate treaties and why some fail and others don't, why some succeed and others fail. And so there's been a lot of study and analysis of the impacts of treaties, but very little about how they're created. So what I did was start with what international lawyers call the travaux préparatoires, or negotiating records. And this actually involved hand-coding those records and identifying the positions that every state took on every issue discussed over the course of the negotiations. So these negotiations often span months, often even many years. Right? So because these diplomats use the language of diplomacy, they talk in subtle ways and so forth, we actually don't have the technology yet to really reliably code the text there. So we use hand coders, people trained in international law, including myself, look these over, and we convert the positions into essentially like votes, in the same sense that political scientists who study Congress, who study courts, as Mike just referred to, would count the votes of members of Congress or judges. I can treat these positions as votes, and then I can do what we call an ideal point analysis to identify, to convert these votes into a number on some number of dimensions. And the model, through the different types of votes, tells us how many dimensions there are. So for example, with the International Criminal Court, there were mainly two issues that divided the parties. One was about the scope of authority of the court, and another one was about what types of crimes the court would be considering. And there were real schisms between, say, major powers and Islamic law states and so forth. And so we can take that data and plot it on a graph and then see visually where each state stood on any number of dimensions, assuming it's 2 or fewer dimensions at least. We can see where they stand, and then we can start to make predictions about who will ratify the treaties. And in the work I've done so far, I've been able to predict with a reasonable degree of accuracy which states would ratify the treaties and which wouldn't. And the hope going forward, I'm applying for an NSF grant right now with a co-author, is that we can use this for not just past treaties, but ongoing treaties, and predict what positions or what tweaks to the treaties and what terms would result in the most number of ratifiers without losing substance and so forth. with the idea that there might be an NGO or so forth that would use this technique to help treaties become more successful, make them more likely to be concluded and ratified by a significant number of states. And then the last one real quickly is also about judicial ideology that Mike alluded to. So political scientists especially have been trying to understand why judges decide cases as they do. And they've started over the last few decades to try to assign an ideology score to judges. Each of these methods is kind of ingenious and unique in its own way. It involves looking at who appointed them or who supported them in the Congress. It involves looking at votes. I have a project right now I hope to submit in the next few months for review that takes all of the Article III judges, that is all the judges with life tenure, both district court, circuit, and Supreme Court justice, and puts them on the same ideological scale. And the way we do this is we draw on something, a compendium called the Almanac of the Federal Judiciary that's been published since 1985, where a Walters Kluwer, a publisher, interviews tens of thousands of lawyers about their experience with the judges and gets their responses in their own language. And so it turns out there was only one of these remaining in the world. It was sitting in an office in Manhattan in the publisher's office. And so I went to see her. I had a number of meetings with her. I said, okay, is there any chance maybe I could scan these, try to convert it to text, or even better if you have the files, the original files. And she said, sure, you can scan them. We don't have any electronic files, and then you'll get a kick out of this. The reason they don't have the electronic files is about 8 years ago, maybe 10 years ago, they were moving offices, and they had the electronic files on one of these zip disks, if you remember those. And so they said, oh, what's this? This is a zip disk. And they went around like trying to figure out where they could put it in different holes and computers, and they couldn't find any place that would fit, so they threw it away. And with the So, I mean, that's both good and bad for me. It means that nobody else could scoop me on this project because no one else was willing to scan the 100,000 pages of these 30 years of reports. But I was willing to. I now have the text. And so I'm using text analysis along with a co-author to a dictionary-based method to assign ideology scores to each of these judges. But because the lawyers are evaluating other attributes of them, such as their ability, their temperament, the opinion quality, approach to settlement for district court judges, I can also estimate a score for each of them and rank all of these thousands of judges on a number of different scales. And because we don't have a single scale for all federal judges today, I hope that once this project is done, it'll open up a whole new line of research that wasn't possible before due to the data limitations. So with that, I'll end and look forward to your questions.
So I'm going to ask one question before I open it up, which is when I listen to you, it seems, there's an obvious question, but where the data come from is clearly so important. And, you've described, though you haven't necessarily brought out this piece of it, different ways of getting data, right? Supreme Court opinions already exist, right? You're fighting with ICE to get the data. They're all different ways. So when you think about this new field and your scholarship in the future, do you think there's so much data out there waiting for us and we can't possibly do it all? Or do you think, boy, it's going to be a hard thing to get the data I want? And and the secondary question, do you start projects by thinking about what data are available, or do you start projects by thinking about questions and then trying to identify where the data will come from?
Right. So just to kind of take a crack at that. So all of the above. And really, so on the data sources, for example, so I do think there's so much that we could spend lifetimes going through this data. For example, public comments into regulatory proceedings. So like EPA opens a regulatory proceeding and receives 300,000 or 1 million comments. And there are, hundreds, thousands of regulatory proceedings that where this data exists. So there's mountains and mountains of data, but at the same time, when we have question-driven approaches, the data might not exist that we want, right? So even though we have mountains of data, the mountains of data might not be the data that we want to have. And even when we have a mountain of data, we have to be very careful about the data generating process and understanding that process and what it tells us about how we can do inference. So just a little thumbnail story about that. So I have another paper. That's what academics do, just pitch their papers to people. But in any case, I have another paper that what we do is we look at this question again of judicial ideology. This is something that a lot of folks are interested in. And one of the facts of this field for the last 30 years, longer, is that it's based on opinions that are published. Okay, so we're doing a statistical analysis of the question is whether panels, usually 3-judge panels in the appellate courts, whether they, Republican judges decide more conservatively than liberal judges. This is a great data thing for people who are interested in data, right? So you do this analysis, and it turns out, let's just say in criminal cases, Republican judges, having a Republican panel correlates with a decision against the criminal defendant. Okay, that'd be what our expectation would be, and you control for the year and the circuit and other things. And so you say, okay, we have a causal claim here. We have a causal we've identified because panels are set randomly. Okay, so we have randomization. When you're randomly assigned a Republican panel, and you're a criminal defendant, you're more likely to lose. Okay, but there's a problem here, which is that the same panel decides whether to publish the opinion or not. There's a whole world of opinions that are not published. There's a massive sampling problem here. So it could be, for example, that Republican judges just prefer to publish cases when defendants lose, but they're actually equally likely to vote on the merits either way. You don't know. You can't tell. And so what we do with what text analysis can help us do is we take all of the published opinions, because you never can know if you have the whole world of unpublished opinions. Some of them are truly unpublished. Some are kind of published. It's quite complicated. But if you get the world of published opinions, you can start to look for statistical regularities that you should not see if they were essentially a random sample. Okay, so you can look to see whether it's a biased sample, and we find that it is actually pretty substantially biased. And so, like many claims, causal claims about the role of ideology in the courts have been based essentially on a biased sample. And so we have to really question, the veracity. So just to return, that's a situation where we have tons of data. There's a mountain of published opinions, but it's not the whole world, and the way in which it's not the whole world is very important for, in terms of drawing implications from the data.
Yeah, just real quickly, because I want to get to your questions. To answer your question about which comes first, the data or the question, again, I agree that it depends. I've certainly been involved in projects. I just mentioned the ice scraping project, where I think it was more about, hey, we have this technology now to do this, and we want to get these data before anyone else does, so we'll scrape it and then come up with a research question as it goes along. There has to be something we can answer, And so some projects are very much data-driven, but most of the stuff that I've worked on has been, there are these questions out there that the folks have been trying to answer for some time, but due to lack of information, whether the information not being publicly available or hard to get as if being in some physical space instead of on the web, or just a lack of computing power to analyze it. So that's true with the treaties project, right? We've for a long time wanted to understand how treaty negotiations are done, but we haven't had good ways to get at it. And recently, in fact, and here I'll plug our fabulous UVA library, and John Ashley sitting in front, who is part of, the UVA library collected these negotiating records from the major human rights treaties a couple years ago, actually went to New York and Geneva, I think, got them off of the microfiche, which is still a thing, and went up and put them on our website, which is now available to all of you and to the whole world to analyze. So that was a tremendous step forward, and it allowed me and others to do the types of projects that I talked about. And also with the Judicial Ideology project, this notion, the ability to do optical character recognition. I guess with the Judicial Ideology, it was one step forward and one step back. So they threw away the zip disk, which was a step back, and so I had all these pages, but then optical character recognition has come along, and so I can convert it back into data, into a TXT file, And now we have more sophisticated text analysis techniques that allow us to apply dictionaries to these sorts of things. So those were both where, I had these questions in my mind, other people did, but as these technologies are evolving and as availability is rising, we have the ability to answer them.
Great.
Thanks. This question is, you can feel free to dispute the premise here, but assuming that one of the goals of qualitative analysis of legal data is not just to understand past outcomes or predict future outcomes, but to provide tools to change future outcomes, and this is all sort of in a system that is heavily rooted, in it's not deeply embedded with data. I mean, you have issues where you can provide a judge, the product of an algorithm that says these people have whatever score for a bond determination. Are they risky? Are they not risky? And the judge just looks in his face and says, I can tell he's lying, And that's built into policy, that's built into basically all aspects. So, I guess this is a two-part question. How do you identify not only things that are sort of interesting topics to understand outcomes, in their own merit, but something that may answer sort of an anticipated question? And then how do you use that, and how do you overcome sort of a resistance to quantitative conclusions in a sort of qualitative world?
Great. So I'll just offer maybe just a few preliminary thoughts about that. So there are really massive opportunities here in terms of one way to maybe put a slight gloss on the first part of your question is using data analysis to inform legal decision making. Whatever it is, it could be a bail determination, it could be sentencing, it could be an administrative determination. It could be a legislative decision. It could be a rulemaking, right? It could be an enforcement decision. There could be lots of different ways that data could inform some kind of legal determination. So just to throw a couple examples, of course, the bond context has gotten a ton of attention, right? And that's good, and it's a very important and interesting context, and there are lots of important questions that are raised by it. But in a way, I do wonder where there's almost been a little bit of a disservice to the broader field that we focus so much on criminal justice, which really has its own set of issues that are not necessarily universal to other decisions. So I'll just throw another example of something I'm familiar with, where the EPA, the Environmental Protection Agency, used data analysis to inform its decision about checking up on underground storage tanks. Okay, so you've got this nasty stuff that's sometimes buried in big tanks that's underground, and sometimes those tanks leak, and it's not good for the environment. But EPA has limited resources to do these inspections. So how can it maximize the use of that limited resource to find the tanks that are going to be the bad tanks, basically? And so there's data that the agency has, and it can, it has done some sophisticated analysis to then, figure out how to target its resources. And so that's a case where if the agency was happy, I think people with leaky underground storage tanks were not happy, but people with good storage tanks were probably happy, actually. And so it's never going to be win-win for everybody, but the agency was more than happy to take on that type of information, right? Because it was helping it do its job in a way that it kind of readily saw. And I think there are many contexts like that. Now that having been said, there are going to be contexts where either the use is more controversial, or where decision makers may feel threatened by the technology, right? Either because it's going to automate something that they used to do before, or they don't trust it, right? And this question about building trust in some of these technologies is a really its own massive question in data science and in computer science generally, about this kind of human interface with machines and so on. Autonomous vehicles kind of raises similar related things. And so we're just starting to think about this stuff. I think judges probably aren't the best case for like early adopters of technology and data. But there's also generational things, and the judiciary turns over slowly, unlike other areas of life. And so again, maybe they're not the best test case, but in other domains, I think the barriers to adoption are much lower.
I'd echo what Mike said. I'd just briefly add, I think that some of the pushback occurs when researchers are less careful than they should be about the conclusions and the implications they draw from the data. I think there are not everyone, and certainly not a majority, but a large number of quantitative researchers who think that large N data analysis is a really good substitute for other types of analysis and other types of research, such as case studies or mixed methods and so forth. And so you sometimes have, I've seen this in political science especially, people working on courts and so forth who don't really understand how cases are tried. They like to think of courts as basically judicial akin to legislatures. There are also people working on treaties who are not familiar with how treaties are negotiated. So one thing I try to do is realize that my expertise is limited, and I always try to do a reality check when I find quantitative conclusions by talking to experts who have been in the field, saying, does this really jive with your experience? If it doesn't, well, maybe I've made some groundbreaking finding that nobody else knows, or maybe I need to go back and reconsider the model and reconsider my assumptions. So I think that's an important part of it, and I think doing more of that would give data analysis more credibility, especially in legal circles.
Right.
So I just comment very briefly that a zip disk, when you're as old as I am, it's actually new technology.
Well, it's not the big cartridge you have to put on the thing and it spins around, right?
But so just a question about, obviously since we've been meeting, this notion of the law as data is something really intriguing to me. But just also sort of a mandate of the school as we develop is essentially papers are important, but it's actually the translation that's really important. So my interpretation in this case would be what I would call a virtuous cycle, where the law as data has uncovered something which has then virtuously come back and changed the law. Are we too early to see examples of that yet, or are there examples that you can think of? And will they come? Do you think they'll come? If they're not there yet, will they come?
Yeah, I mean, I think that there are. Well, certainly, if it depends on how broadly we're thinking about this, the inquiry, right? So if we think, more kind of blown out in terms of, laws, data, actually, in the context of judicial ideology, I mean, in both good and bad ways. I think that there's ways in which some of the work on judicial ideology has been over-interpreted, such that it is, and even in a way that has really actually influenced the process of judicial nomination. I think that's completely plausible, actually, is that in part due to social science research, which in some ways I think wasn't as careful as it could have been, overemphasized the role of ideology in the mainstream of kind of judicial decision making, and that kind of led to an emphasis in the press and an emphasis in the legislature on judicial ideology in the process of nomination, and has become kind of really an overwhelming feature of our political system. Now, I'm telling a causal story there. Do I have a carefully identified model? No, it's a little historical, but and impressionistic. But that's an area where I think data analysis that could have been more careful has actually led to changing political climate. That, or at least contributed to a changing political climate that hasn't necessarily been a good thing. But I think certainly empirical legal studies more generally, in areas with like program evaluation, where you're trying to identify government interventions that are or are not successful at achieving some goal, that type of work is very beneficial and has been absolutely used in policymaking. That's not the law as data piece as much, but that's certainly data analysis that then goes into informed policymaking.
Oh.
This goes back to Mr. Livermore's comments about biased data earlier. So I was wondering how you're able to determine that the data is biased, and how do you know that it's the data that's biased and not necessarily your analysis?
Well, my analysis is never biased. So that one's easy. Okay, well, so I'll give you the example from this paper that we're using, right? So the question is, there's this world of decisions, right? Courts make lots of decisions, and a small percentage of them are ultimately discussed and written up and published in a published opinion. So let's say 10%, all right? Now the question is whether that 10% is essentially representative of the broader group, okay? And representative vis-a-vis the kind of thing that we're interested in. So then here's one of the ways that we test that. There's actually several, but I'll just give you one. So judges write all of the opinion. So you can't use any information really in the opinion, or you have to be worried about that. But they don't write the case caption, which is where the names of the parties are. Okay, the names of the parties are just there, right? They're just given by the parties. If there is no bias in the selection process through the judicial ideology, which is what we're trying to study here, or really a better way to say that is through the party affiliation of the judges, which is what we're studying. So the question is, do Republican judges vote differently than Democratic judges? So then we would worry that if Democratic judges publish different kinds of opinions than Republican judges, right? Because that's a bias in our sample. So what we do is we look at the question of whether the opinion caption, and specifically whether the word United States versus X, which is basically whether it's a criminal case or not, whether criminal cases are more likely to show up if you're a Republican judge versus a Democratic judge. And we control for like time and circuit and other factors that would take that in, that would confound that. And what we find is that actually, other things being equal, Republican judges, if Republican judge-dominated panels, have higher numbers of cases with the United States as a party. Okay, that should not be. If Republican judges were publishing the same types of cases in a totally essentially random way as Democratic judges, then that pattern should not exist. Okay, so basically that's one example. We do this with several other case features, where essentially what we're doing is we're looking for patterns in the data that we observe that would not exist if it was a representative or random sample.
Yeah, so bias in data sets is a big issue. I think people are increasingly starting to pay attention to it. That's why I prefer to collect all my own data so that I can assure that there are no errors in it. But there are increasingly people will, when they're in the process of proposing a new data set, will workshop that, will shop it around, and even will publish the data set and some preliminary analysis of it as a paper unto itself, just to show how the data were collected, what processes were used, and so forth. And in that way, before the analysis even happens, it's subject to peer review, it's subject to critique by the public and so forth. And in that way, I think we can minimize bias in data collection itself.
Yeah, I've got a question.
I'm trying to find the
mic.
microphone.
Oh, there's someone
somebody
in the
has it
back.
So
Sorry.
here next. Yeah.
Hi, Claudia Schultz, Associate Director for Research Development at the School of Data Science. I have two questions. The first is brought on by the comment about having to web scrape the ICE press releases. And I'm wondering if any of you could comment on the applicability or ability to use Freedom of Information Act or other government transparency policies and legislation to compel agencies to hand over documents and data in the formats that make it amenable to analysis, and whether maybe the School of Data Science should be advocating for certain kinds of data accessibility policies at all levels of government. My second question has to do with, Michael is going to know exactly what I'm going to ask. We've talked about in this session law as data, and I do want, before this legal brain trust disbands, to get on the record some comments about data as law, in the sense of algorithmic decision-making in criminal justice, in the sense of the role of privacy law in the use of algorithms, and even in labor law, right? The scheduling of workers by algorithm, right? So if you could address either or both of those,
Yeah,
I'd be very happy.
I can address the first question. So I've been fortunate in the data I've collected that I haven't had to use FOIA requests. This is really probably a better question for our librarians who, yeah.
I can answer this one.
Okay.
She's
So when the
bringing
mic,
you the microphone.
yeah, when the microphone moves up, maybe. Oh, there it is.
So, excuse me. So my name is John Ashley, and I'm head of the Legal Data Lab here at the law school. And I have supported law school faculty for years. My experience with FOIA, I've sued the Department of Justice twice and won both times, fortunately. And these were for non-prosecution agreements. So it's not maybe structured data that you would prefer, but it was data that we obviously couldn't get otherwise. And we submitted the FOIA request, and the Department of Justice totally stonewalled me. And it turned out that we had to sue. The second time was actually much, much easier. It was with the Department of Labor, and this was getting mutual fund plan options for every company in America with over $1 million in assets. And that process was super easy. And I'm sitting at the moment on a pile of 600,000 PDFs. But the trick to this, is that I need to extract one table out of these PDFs. And the tables are formatted differently. And sometimes the table is duplicated. So this becomes pretty quickly a sort of OCR-ish / computer science kind of problem. But I think it sort of depends on the agency that you're working with in terms of FOIA and how willing they are to provide the data that you're after. But I think the more resources that are there to open up government resources that are behind FOIA requests, the better. So.
Yeah, what I usually say about FOIA is great if you if you're going to live forever. Right? It's a very time-consuming process. But I think that just to build slightly on what John just said is the format of the data is so important, and it's just not contemplated in FOIA. Like the government can actually comply with a FOIA request by just dumping paper on you, and so they don't do that anymore because it's expensive, because paper costs money. So they just they scan it and they give you 600,000 PDFs, which is like, that sounds horrible to anybody that does data analysis, right? And so we really need a kind of a next generation of laws, and some agencies are better than others. Some are better about having standard formats. There have been efforts to standardize data across government, but and one interesting question is, what role, if any, can courts play? Because FOIA's, the thing is, if the agency doesn't do a good job or doesn't comply with your FOIA request and it does it so unlawfully, you can go to court. But that's not but the kind of stuff that we're talking about, like the government proactively going out there and formatting data, creating default formats that are simple and easy to use for data analytics. That's a very hard thing for a court, to sue an agency for failing to do that properly and for a court to supervise. And so I'm not sure what the template looks like there, but something is absolutely needed, kind of a next generation approach to this. So on the other kind of set of questions about, yeah, we've been talking about law as data and what we can learn about the law from data analytics, but there's also the law that governs how data is used, basically, right? In the context of courts, in the context of private employers, in the context of government agencies, in the context of Uber and Airbnb, and there's just many ways that sophisticated algorithms and data analytic techniques are being used to influence decisions about us in so many different domains. And the law is just starting to kind of catch up in this area. I think the way I think of this, I actually consider myself not an expert in these set of questions, but the way I think of this is that we're literally just starting to think about what the normative implications are of all of these developments, and we are both just even what the problems might be, and then it's actually quite hard to develop a normative understanding of. So we have a colleague, Debbie Hellman, at the law school, is one of the leaders in the country and the world in thinking about discrimination and the philosophy of discrimination. What makes discrimination bad from a normative and moral perspective, and just cashing that stuff out in the context of data analytics is incredibly requires a lot of very sophisticated thought. And I think we're really just starting on what's going to be a very long road of developing the fundamental normative understanding of what the stakes are and what the right way to think about this stuff are, and then translating that into legal and governance regimes. I really just think it's super early days, but it's something that's absolutely vital and needs to happen.
And I would just add, from the dean's perspective, this is a wonderful panel, and I'm so glad the three of us are here. But there are many other people at the law school who are working at these intersections. We could field several additional panels with Debbie Hellman, with Ashley Deeks, who's thinking about these questions in the national security context, and so I think there are lots of folks at the law school interested in those conversations too.
This may not be well addressed, but I'm just curious, there's always the issue of dog fooding, right, where you get the data from where you are. So, UVA produces its own data sets, most lately kind of suing a bunch of people who were, in the medical system, right? So in terms of looking at that data and processing our own legal data, what thoughts do you have on doing that? Is that being processized? Is that something, if we're going to be kind of made to take this seriously, we should probably be looking at our own house first, right? And I'm just curious whether that's being laid out instructionally in classrooms, or how, our own data is being processed in the broader sense.
I'll say I know a few things. So one, I know that both the provost and the president are very interested in our faculty using their expertise. I don't know that they've thought so much about where the data that expertise is going to apply to comes from, but that our faculty use their expertise for institutional development and assessment and toward best practices. So I imagine some of that involves large amounts of data. And then the second thing is that I know we have spoken as the leadership of the schools about identifying ways to do more institutional data collection and accessibility. So I don't know, Phil, if you have more you want to say to that, but I know that we are thinking about it, and I think it's something that will be better developed in the future. Do you want to say something, Phil?
Well, we have to stop, but I would just say that I think it's an opportunity, and it's something that the leadership is now beginning to recognise. I think we have quite a lot of way to go. We don't sort of have the necessary data governance to actually even begin this process, and it's telling. If we create a school where we're turning out data scientists, we should be hiring them ourselves to actually make ourselves a better institution. And I think that the realization for that is starting to happen, and I'm cautiously optimistic.
Great. Thank you all so much for coming, and thank you for hosting this panel.